Our next case is People versus Spears. This is also a 15-minute mini oral argument on the application. Good morning to you both. You have 2 minutes of a free fire zone, which you may waive. You may reserve time for rebuttal, but we ask that you keep track of your own time, and you may begin when you're ready.
Okay. Thank you, Your Honor. May it please the court. Ian Kerp on behalf of Mr. Spears. Good morning, Justices. I would like to take my 2 minutes for free fire and reserve 2 minutes for rebuttal. Mr. Spears is entitled to relief because the trial court advocated in his constitutional duties to ensure that Mr. Spears read and understood the important constitutional rights he was waiving by pleading guilty. And because the trial court did not ensure that Mr. Spears understood these important constitutional rights as he was waiving by pleading guilty, he is entitled to plea withdrawal on that issue. On the second issue, during his plea, the prosecution failed to establish any evidence that Mr. Spears acted with malice or without justification or excuse when he shot Mr. Marzette. And because of that, the remedy there would be this court would remand to give the prosecution an opportunity to establish that, which I don't think they'd be able to. And then Mr. Spears is entitled to relief here because his initial appellate counsel on direct failed to present these issues in direct appeal. For these reasons, that was ineffective to do so. So we've established good cause, and to allow the convictions to stand would constitute manifest injustice. Turning to the first issue, and I'll waive the remainder of my free fire at that point. Turning to the first issue here, when Mr. Spears pled guilty, that's a very solemn and grave act. It's not a trifling matter. There's important things that a defendant, any person, needs to know when they're pleading guilty. Because when you're pleading guilty, you're waiving very important constitutional rights: the right to a jury trial, the right to confront your accusers, and the right to remain silent. In effect, when you're pleading guilty, a defendant is saying, I did these acts, I'm guilty of a crime. They're acting as a witness against themselves. So it's not like some discrete set of acts that they're agreeing to. They're actually saying, I'm guilty of this. And before we get to that point, and before a person waives those important rights, it is important that the trial court ensures that the defendant, Mr. Spears in this case, is aware of those rights, understands those rights. And in this context, we had the writing used by the circuit court. He signed it. All the trial court asked was, did you go over this with your trial attorney? Trial court never asked them, did you read those rights? Did you understand those rights? The trial court never even asked them those questions.
Would that have been sufficient? Would we not be here today if the trial court had said, did you read these? Do you understand these? Are those questions enough?
If the trial court asked Mr. Spears, did you read these rights, did you understand these rights, and if he answered yes, then we would not be here. Correct. Okay. But the trial court did not. And as this court
Isn't having the attorney explain them to you arguably more protective than somebody reading it who doesn't perhaps understand the legal ramifications? I mean, isn't it having the attorney explain it to you actually more protective than just saying, well, did you read it and understand it? You have somebody explain it to you.
Well, we have nothing on the record here if his trial counsel actually explained these rights to him.
Well, he asked him and he said, yes, he did.
Right, but we still,
yeah.
but we still have nothing on the record if Mr. Spears actually understood what these rights are and what they meant. It's one thing to say, hey, you have a right to remain silent, or a right to confront your accusers, but if you don't understand what those rights mean, how can you knowingly waive those rights? And here the record is devoid of that. Did he actually understand what that meant? And I think that's important because, we're pleading guilty, in this case, to murder, but in any case, when we're pleading guilty to a crime, it's important to know, what are my rights? And do I really want to waive these rights? Do I want to waive my right to remain silent? Do I want to waive my right to this trial? Do I want to waive my right to confront my accusers? So those are very important rights, and I think that, and we have to ensure, and where this court has gone and where we've been proceeding here, is making sure defendants understand certain rights that they're waiving, right? We've introduced Padilla, Free Kentucky. We've brought in, we're ensuring defendants now understand they have what their maximum penalties are. Source issues, we're ensuring the defense understand, before they're pleading guilty, they understand what they're doing and rights they're giving up. But here, these are more important constitutional rights that we're talking about. And when we get to Boykin and Jaworski and Saffold, we don't have the issue of substantial compliance here, because these are Boykin rights. We're going to get to that issue of substantial compliance here. if the trial court, in this case, was completely omitted from asking Mr. Spears if he read or understood those rights, reversal is automatic, according to Boykin, Jaworski, Saffold, and the circumstance. I'd like to touch on Ingram for a minute. I know that was brought up in Appellee's brief. And Ingram is certainly distinguishable here because Ingram dealt with a defendant collaterally attacking a conviction used to enhance his penalty in the case he was on. And that happened again in Ward. And certainly we've had advances from there. Certainly C-500 motions are a thing now. And again, we've introduced new things, Padilla, additional rights that the defense have to make sure they're aware of. And we got C-500 motions, which allow you to collaterally attack your conviction because your direct attorney on appeal is ineffective. And here that's what we have. And so I don't think Ingram even applies in the circumstance for those reasons because we're alleging ineffectiveness as a counsel, and certainly things have changed in the context of pleas and how we're going about it. And here in this case, Mr. Spears isn't collaterally attacking a prior conviction used to enhance anything in this present case. I mean, we're attacking his conviction here.
Explain to me why you don't think substantial compliance is really the guiding standard, right? Compliance with the court rule, substantial compliance is what is required. A complete omission of Jaworski rights would mandate a reversal, but a imprecise recital of a Jaworski right is still substantial compliance. So I don't think you're contending that this is a complete omission of the Jaworski rights. It's incomplete. Why is that? Why should we still not look at that for substantial compliance?
Well, Your Honor, I guess I would say we do have a complete omission here because the trial court never specifically asked Mr. Spears, did he read and understand he have a right to confront his accusers and remain silent? That was completely omitted. It's not enough that he went over the form. For the Constitution and the court rule, and Jaworski, Boykin, Saffold, the court has to ensure he reads and understands specifically those three rights. The other rights that you waive by trial, if it's in precise recital, I would agree, substantial compliance would suffice. Or if the judge somehow had said, you're waiving your right to not speak at your trial or something, not use the precise language of remain silent or the precise language of right to confront your accusers, then I would agree that substantial compliance would be satisfied here. But here it's a complete omission. Like the trial court has never been asked or advised them of specifically those two rights. And moving on to the second issue here, without justification or excuse as being an element of murder, as this court has long held, murder is the intentional killing of another human with malice. This court has adopted the common law definition of homicide and murder, which incorporates malice. And what is malice? Malice is what distinguishes between what is murder, homicide, and what isn't. And we're looking at what malice. Malice encompasses the idea of without justification or excuse. Malice is an essential element of murder because if you don't have it, you don't have murder or homicide. You have something else. You have self-defense, you have manslaughter, you have negligent homicide, something along those lines. So when we're talking about without justification or excuse, it is an essential element of murder because that encompasses what malice is. That's what the prosecution has to prove. That's what makes it murder in this context. And when we're talking about as a negative element or not, if we don't have malice, there is no murder. So it's not like we're talking about duress or coercion or insanity where, yeah, I still did the act, but it's excused because I did this.
Isn't justification or excuse, isn't that language referencing an affirmative defense?
No, and I think there's a Court of Appeals case from 71 People versus Moran that talks about what malice of forethought is. And it says malice of forethought encompasses certain defenses, like without justification or excuse, but not others, like coercion, mistake. And they say those don't necessarily negate the malice. Without justification or excuse negates the malice. If that's there, there is no malice. You can still have malice if you're insane. You can still have malice if it's coercion. But as that court indicated, malice encompasses without justification or excuse. Like it's part of malice, but you have to prove to get murder. It's an essential element. So if you show there's without justification or excuse, there is no malice. there is no murder. You can't call it a murder. I mean, whereas if you're insane or coerced or some other act, you can.
Counsel, do you agree that what you are arguing would be a pretty substantial departure from how it works today? I think it was Pam's brief noted that in every case that all of these elements would have to be proven. Is that is a deep departure from how we've done it in the past?
Well, you still have to establish malice either way. So either at trial or during a plea of bargaining or during a plea, there still has to be some evidence of malice. I don't see how we can get away with that, and I think perhaps...
if presented by the defense?
Sure, right. I mean, conceivably at trial, a defendant could say, hey, I have an alibi, I wasn't even there, so I'm not contesting the malice issue. In the context of a plea, at least in Mr. Spears' case, where there is some pre-trial, he says someone came out with a gun, we're here to discuss why I shot this individual. There's certainly enough there in the context of a plea to say, hey, malice without just an excuse is a potential issue here that I think at least the trial court or somehow needs to be addressed, or it needs to be established that he didn't act, that he acted without justification or excuse. I don't think it's going too far at a plea hearing to require one additional question, you know.
How does that get raised at a plea hearing? Is it on the judge to say, hey, I think there might be one of these other elements? I better make sure that I ask about them. And I mean, or is that, I mean, I get at trial, right? Mm-hmm. When that's being raised as a defense to negate the malice element. How does that get raised at a plea hearing?
Well, I think it can just be part of the plea colloquy, you know.
But doesn't that go to the point then of doesn't the colloquy need to sort of cover all of the possibilities? Because I better make sure it wasn't because of insanity, or it wasn't because of, you know, all these other affirmative defenses or elements, if we're going to consider them that, because I need to make sure that the confession is, or the plea is voluntary and understanding.
Okay, and I think we can differentiate between those when we look at what is malice, what does malice encompass, which is strictly just without justification or excuse. We don't get into other affirmative defenses like coercion, duress, mistake, insanity. So if we simply say, you know, did you shoot the victim? Yes. Did you intend to kill them? Yes. Did you do it without justification or excuse? Yes. That could establish that. We don't have to go through everything else. If we're just concerned with malice and what is malice, which encompasses without justification or excuse.
So you're saying it gets raised, it should be asked in any colloquy then?
I would say yes. Because malice is part of murder.
Even though if at trial, it doesn't come into play unless the defendant raises it, such that then the prosecution has the burden to prove the negative, right? At a trial, it doesn't automatically get submitted, right? The defendant has to raise the issue that actually I did it in self-defense or with a, you know, justification or excuse before it's even at issue. So why would the plea just assume it's always at issue and always advise again, and, you know, always inquire about it?
Because at trial, regardless, you're still proving malice. So a defendant may not dispute malice at trial for strategic reasons, for whatever reason. They may not dispute it at trial. You know, we're taking a plea, you know, the defendant has to put on a factual basis why I'm guilty. And certainly malice would encompass that in that regard, because he's not saying alibi or whatever it is. I mean, conceivably, maybe he could concede malice at, well, he is conceding malice at a plea hearing, but he has to understand why he's conceding it, and he's doing it without justification or excuse. So. And
so he has to put on the record that, you know, all of the negative, as well as.
No.
Well, it sounds like that's what you're asking. If they have to say no, there was no justification, there was no excuse.
I think that's all we have to get to, Justice Clement.
Say that again?
I think that's all we really have to ask a defendant.
Why, but why? We don't look at the elements of any offense and then say you have to tell us the negative. You know, you just have to say that these elements existed. You have to say these
Well-
things didn't exist.
In the context of like a UDAA, where you have to actually say, I took this person's car without their consent. In retail fraud, I took these items from the store without the owner's consent. So we're still showing a negative. I did something without somebody's consent here.
But that's one of the elements.
And malice is an element of murder, which encompasses without just...
Malice, not the, and I did it without justification. I mean, I guess I'm not understanding if we're going to set rules of what has to be done at a plea, it needs to be very clear, and if that's never even come up in the case, why would we expect every defendant to have to put that forward in their plea?
Well, I think it's important because we have to establish that the elements of murder at a plea, which does encompass malice. We have to establish that there's malice there. Because we don't have malice, it's not a murder or a homicide. And what I'm saying, and what I'm arguing is that malice encompasses without justification or excuse. So there has to be some evidence there produced at a plea hearing that this was done without justification or excuse, because otherwise, how do we know there's malice in this instance?
But that's not how it works in a trial. There has to be evidence that there was justification or excuse.
Yes, I agree, to get that jury
But you were
instruction.
asking for the flip of that at a plea.
Well, because at trial, obviously, you have the defendant who's putting on defense and is arguing certain things. We don't have that at a plea. The defendant doesn't come out and say, this is what I'm defending this case on. There would be no judgment at the plea.
Exactly. I think that's my point.
Right.
I mean, the defense to that plea was there was justification or excuse. Why would they have to provide that they don't have those defenses at the plea?
If I understand the court is asking...
Do they have to say, I do not have an alibi?
No, because an alibi is not part of malice. Have I answered your question?
I think so.
Okay.
Thank you.
Thank you. Yep.
Good morning, Madam Police Chief Justice. May it please the court. My name is Joseph Schopp. I'm appearing today on behalf of the people of the state of Michigan. Obviously, this court, in its May 29th, 2024 order granting the MOA in this case, granted leave or at least directed argument on 3 issues. I'm going to focus on that second issue, the issue of the elements of murder, because I think it is the existential issue in this case. What are the elements of murder? Obviously, there are hundreds of, if not thousands of murder cases in the state every year. And of course, at trial, the people always have the burden of production and persuasion to prove all elements of the charge beyond a reasonable doubt. And so I just want to basically reiterate the existential consequences in our view of a holding that, quote unquote, without justification or excuse is an element of murder and not simply the negation of a series of affirmative defenses. The first, what I would consider serious consequence is that it would basically exponentially multiply the proofs that would be required at trial to prove all of the quote-unquote elements of murder. As this court probably knows from reviewing dozens, if not hundreds of murder cases every year, it often takes the prosecutor a week, 2 weeks, or even more to prove what we consider the 3 true elements of murder, which is the death of a victim caused by the defendant with malice. Having to disprove every possible affirmative defense of murder in addition to those 3 elements would probably exponentially lengthen these trials. And a lot of these defenses are just, quite frankly, ridiculous, even a cursory view of the facts of the case. For example, the infancy defense, I mean, a lot of times the jury could just look at the defendant and be like, obviously he's old enough to be charged with a crime. But the people, if it's an element, would have the burden to disprove this defense along with the dozens of others beyond a reasonable doubt with affirmative evidence.
What do you say to Brother Counsel's argument that it's not just an affirmative defense, it's actually an element?
Well, I would go back to basically the history of this that I laid out in my brief, going back to Lord Hale. I think his treatise was published in 1736, but he died in 1676, so obviously his words go back to at least the 17th century, saying that once the intent to kill, intent to do great bodily harm, or depraved indifference has been proven, malice was presumed at common law, And it was incumbent upon the prisoner to put forth some evidence, what we would now call meet his burden of production, of some justification or excuse. And then, once the defendant does that, then the question becomes whether the jury, as the finder of fact, believes that that defense is valid or not. Obviously, some affirmative defenses, once that burden of production has been met, shifts the burden back to the prosecutor to persuade the jury that the defense doesn't exist, and then others, I guess would be true affirmative defenses, puts the burden on the defendant to produce.
So would it be fair to say that all affirmative defenses are not elements of the underlying crime?
Yes, I think they're mutually exclusive categories. Something is either an affirmative defense or an element. It can't be both. And there was a case called Lively, which I cited in my brief, and the issue in that case was it was a perjury prosecution, and the parties did not dispute at this trial for perjury that the supposedly perjured testimony was material to the case, which is an element of perjury. Because the parties did not dispute, I guess it was obvious that the testimony was material, that was allegedly perjured testimony. The judge basically directed that element in favor of the prosecution and did not instruct the jury on that element, just instructed the jury on the remaining elements of perjury. And on appeal to this court, the court said that that was error requiring reversal because the prosecution has the burden of proving every element beyond a reasonable doubt in every case, whether or not the element was contested or even conceded by the defense. And that would be the consequence of a holding that without justification or excuse is an element of murder here. Even if the defense agreed openly at trial that there was no justification or excuse being raised in the particular case, the people would still have the burden of disproving all of them affirmatively in every case. And as I mentioned, obviously that would multiply the proofs needed. It would also, as the Chief Justice noted earlier, it would also require the people to prove multiple negatives. For example, the people would have to prove, I'll use the involuntary intoxication defense as an example. The people would have to prove that the defendant had not been drugged for some amount of time before the crime. How would that even be done in the routine case? The people would basically have to trace the defendant's steps for hours, if not days, before the murder to make sure, he wasn't drugged at some point, and therefore that's what caused the crime, not his own free will. And of course, this would just be an impossible burden in the vast majority of cases to be able to trace the defendant's steps, that particularly to be able to prove beyond a reasonable doubt that the defendant had not been drugged. The case would obviously be different if the defendant got on this witness stand and said, I was drugged, and here's the time that I was drugged, and here's how I knew because I felt the effects of it or whatever. Then the people could investigate that particular instance to see, is this allegation of drugging legitimate, or is it just, an invention of the defendant to get out of trouble? But if the people have the affirmative burden to prove the lack of involuntary intoxication, even if it hasn't been raised by the defendant at all, we would have to affirmatively go back probably days to make sure that no drugging had occurred.
So let's assume that we agree with you. Let's go back to the first question that we asked, and talk to me about what the court did here, and was that sufficient?
So as I mentioned in my brief, I agree that there was a strict violation of the court rule here because the court did not, I want to get the language right, obtain from the defendant orally on the record a statement that the rights were read and understood in a waiver of those rights. So the court rule requires the defendant to affirmatively state, I read and understood the rights and I waived them. The court obviously did not do that here. It was much more ambiguous colloquy where the judge referred to the document that listed the rights on it, then asked the defendant, did you go over these rights with your attorney? And he said yes. And then you signed it at the bottom, and he said yes. So that's not quite a statement so explicit as the court rule says. However, I argued, as I did in the brief, that this is substantially complying with the rule because the three, for lack of a better word, elements of this rule is that the defendant was notified of his rights, he understood what the rights were, and he waived them. Here, there can be no doubt that he was notified of his rights on the notice of acceptance section of his written plea agreement sheet that listed all three Jaworski rights and several others. I can't imagine it being more clear than the way that they were written out in that notice of acceptance sheet. Second,
Would you agree, though, that it is an omission of 2 of the Jaworski rights?
So the court did not explicitly name all 3 rights on the record during the oral colloquy.
So why is this not reviewed as an omission of Jaworski rights and automatic reversal as opposed to a substantial compliance?
So I think if you read the Boykin and Jaworski opinions, it doesn't quite, neither one quite says the oral colloquy has to explicitly state all 3. It says, Boykin says that there cannot be a silent record on 3 rights, and Jaworski says the record must show the waiver of the 3 rights. Here, the document, the written plea agreement sheet, is part of the record. Defendant signed it, and it was admitted as part of the record during the plea hearing. So that obviously lists the 3 rights. Then the court...
Yeah, but the rule that says that if you're using a writing, you shall address the defendant, I mean, it seems that our rule says that the form can't be a substitute.
So I think the Al-Shara opinion of the Court of Appeals kind of gets into this. The rule as amended today does allow a written waiver of the rights, but does still require an oral, I think the word that they used was reference to the written sheet as part of the plea. Here the court did refer to the sheet, although albeit a little bit ambiguously, by saying, here's the sheet, did you go over these rights with your attorney, and did you sign at the bottom? So I think it's an imprecise recital. The court actually did recite the jury trial right and a couple of non-Jaworski rights, and then basically just referred to the sheet as a whole and said, did you go over all these rights with your attorney? I would say that's an imprecise recital of all the rights, as opposed to just completely omitting them. Whereas in Al-Shara, I think that's the key distinction with Al-Shara, the court never referred to the written sheet at all. The court basically just went through the other portions of the colloquy and then did the factual basis. There was no reference to the fact that the sheet had ever existed during the oral plea colloquy. And then the second key distinction with Al-Shara, which I think otherwise is the closest precedent to this particular case, is obviously the fact that we are on collateral review in this case as opposed to direct appeal. And even, I think it was footnote 6 of the Al-Shara opinion noted the importance of this. It said, we note, the Court of Appeals in that case notes, this is a direct appeal. Therefore, if this case was on collateral review, however, it might be different. And then it cites Ingram. And I think the Ingram opinion really drives home, I think it just basically makes clear that this is a rule of law. You cannot raise a Jaworski error on collateral review. And the court basically said, at some point, the interests of finality and administrative consequences have to take precedence, especially in a guilty plea case where the interest in finality is particularly strong. And so the Ingram case, I would say, flatly bars any collateral relief for any Jaworski claim. And that's, I understand Brother Counsel's argument about the context of the Ingram case in which the defendant was challenging another conviction in a different case. But if the court reviews the Ward decision, it was kind of reversed. Apparently, a lot of these cases where this comes up is OWI third cases, where a defendant is charged with OWI third, and then to try to get down to a misdemeanor from the felony OWI third, they'll attack one of their 2 prior convictions for OWI. In the Ward case, however, unlike the Ingram case, the Ward case, the defendant did not challenge one of his 2 misdemeanor convictions in the felony case. He actually went back and filed what would now be the equivalent of a motion for relief from judgment in the district court misdemeanor case and said, my Jaworski rights were violated in this case, therefore this conviction is void. And the obvious intention of doing this was to get his felony charge reduced to a misdemeanor. And the Ward case still held, even though it's a review of the district court conviction, not a appeal in the felony case, that collateral review of Jaworski claims is absolutely barred. At some point, finality has to take precedence over the Jaworski issue, and the point where that is reached is collateral review. So in Ingram and then Ward and the other cases that cite this, it's basically a rule of law. The court has decided that finality governs once you get past direct appeal. And I think it was Ingram that even went through why this is actually a good thing, even for the defendants, because it gives them an incentive to immediately review the plea hearings at the time of direct appeal to make sure their rights were adequately protected at the time of the plea, as opposed to waiting years and then coming after the fact. And Obviously, having the rule of law that this must be raised on direct appeal makes it so that the defendant has an incentive to review his plea transcript at the time of his direct appeal, not to wait years later and do it way after the fact. And
Counsel, I want to just jump back to the without justification or excuse argument. We have lots of cases that outline the elements of second-degree murder, and we have a whole bunch that list that as an element.
Yes.
How do we square that with your argument?
so I can't deny there's probably dozens of opinions of this court and the Court of Appeals that do just that. My review of the ones that are cited by the defendants and the other ones that I looked at is that it was never really a holding of the court that without justification or excuse is truly an element. A lot of times when the court lists the 4 elements, they almost do it by way of background. They'll say, the defendant challenges, as an example, the defendant challenges the sufficiency of the evidence on his murder conviction. Here are the 4 elements of murder, and then they'll get into the element that they really are talking about, which is often malice or causation or something like that. So it's clearly dicta, in my opinion, in these cases. They're just kind of citing the Bailey opinion, which is the first one that really did this, just rotely without really thinking about it, because it's not relevant to the particular issue being raised in that case. And then the Court of Appeals opinion in this case obviously goes through that and says, basically, this is not an element of without justification or excuse. You can go all the way back to Blackstone and see that clearly the burden was on the prisoner to prove, at least the burden of production, of some justification or excuse or alleviation. And a true holding to the effect that without justification or excuse is an element of murder would require going back to the common law to see, at common law, was this an element? Because obviously murder is a common law. It's a statutory crime, but it has the common law elements imported through it via the legislature's 1846 adoption of murder without defining it in the statute. So even if the court intended to hold that without justification or excuse is an element in one of these cases, which I honestly don't believe it ever did, it was a holding that I would say bears little to no weight because the court did not do the analysis to make that holding properly. It basically just announced that we are now considering without justification or excuse an element in a case in which it is not really an issue. And that's obviously not entitled to any weight in our
Yeah,
view.
and I mean, I can see how, there's a conflation when something's at trial or a prelim versus a plea. I mean, I see how it's sort of gotten conflated over time. Is it
Right.
an element or is it an affirmative defense?
And
Yeah.
the Court of Appeals in particular will often just recite the elements of the crime when it's talking about sufficiency claim or about anything really to do with the crime. They'll just list the elements of the crime at the beginning of the paragraph and then go into what they really care about. I don't think any of those are true holdings. And like I said, a lot of times the court is just citing an old case and not really analyzing the issue at all. So I would say none of those were really holdings. And to whatever extent they are holdings, they're clearly contrary to the common law history of this crime, and therefore we would ask the court not to follow those. If the court has no further questions, I'd ask the court to deny, leave, or affirm. Thank you.
Thank you both. The case will be submitted.